Good evening, everyone. Thank you for taking the time out to join us on this super important um, issues or law that's being enacted very soon. Some of it is already in place. And this is the Chamber bringing you in partnership with our partners at the Agency of the Department of Consumer Affairs and Workers. I want to get this correctly, Workers Protection. So we're bringing this because there's so many changes going on, and with the problems that we've been having with the pandemic, businesses opening and closing, things seem to slide by and not know. And the last thing we want to see is our businesses be hurt by not understanding laws that are being put into place. We want to make sure to provide you all the tools to be able to maintain regulated and keep your employees safe, keep your businesses running correctly, and that's what we're here for. And to be able to do this, of course, the Chamber can't do it on its own. We always bring in the experts. And in this case, it is the Department of Consumer Affairs with Workers Protection. So we're gonna be running through, I'll be introducing the first Deputy Commissioner, Avelis, in a few minutes. But the conversation tonight is going to be about the New York City's paid safe and sick leave. And I'm still getting used to that new phrase. It was always just a sick leave. And I'm sure you've heard so much about it in various levels, because unfortunately or fortunately, we are covered, we businesses and or employees are covered with regulations at a city level, at a state level, and federal levels. And there's sometimes just a lot of confusion as to who you're supposed to be following, how do you run your books correctly, and all these questions come into hand. So tonight, it really is about having an opportunity to listen. You know, we're gonna have, this is an ongoing conversation. We don't wanna make it too, boring. We also want to make it a conversation, and you have the ability to put questions in the chat. And if by chance we don't get to a question or something you think about afterwards, everything discussed today in this video or webinar will be put on all our social media platforms, YouTube, and we will also be sending out to all our members and non-members on Friday as a newsletter. So like I said, we're going to be going through, I'll be introducing our experts and Commissioner Avelis, I told you I was going to mess up your name. We'll be introducing her staff. We'll run through some of the changes in the law. She'll walk you through the whole process, at which point then we'll turn over. I have with me Ana Reyes, who is a business solution specialist as a program under the Bronx Chamber, who will be moderating the Q&A. Some Q&As that we already have, some questions that we'll be addressing immediately. And then I'll check out for the questions you may have regarding this. Like I said, this is a chat. I'm learning about it myself. Our staff is learning about it. There is so much going on in our lives right now, so we get it if this is just one more to add, but we hope to simplify this portion of it, get you some questions and answers. There's always a website that you'll be able to go to, and we are always here. We're literally a phone call. We'll put Anna's contact information also in the chat, and you can always reach us afterwards. So now I have the pleasure of introducing First Deputy Commissioner Sandra Avelis. And I turn over the table, and I apologize. Like I said, I'm really bad with names. It's a pleasure, and thank you for coming out tonight and joining us and helping us understand all these words.
Thank you so much, Lisa. First, I want to say on behalf of Commissioner Salas, who would have liked to join us tonight, she sends her warm regards. She often does business education personally because she understands how important it is, and we really do appreciate our small businesses and how many challenges they're facing, especially right now in the midst of this COVID crisis. So thank you, Lisa, again for this opportunity.
Of course.
We really appreciate it. It helps us get our message out, and it's really so important to help protect consumers and workers, as is our name. So many of you know us as the Department of Consumer Affairs, but recently we've officially become the Department of Consumer and Worker Protection. And this new name really captures more fully our mission, which is to protect consumers and workers and to enforce the laws that are there for their safety and protection. And so we're really happy to be here tonight and help explain, as so many things change, the laws often change because the conditions change. And so we want to make sure that we're keeping up and that we have all the tools available to us to make sure that workers and consumers are protected. And so a little bit about the agency. Our core mission historically has been to license and enforce consumer protection work. And then once the paid sick leave law came into effect, that became part of our mission as well. And so as that law has evolved and changed to become the paid safe and sick leave law, our Office of Labor Policy and Standards has been charged with enforcing this and other workplace protections. Other work that we do is our Office of Financial Empowerment provides financial counseling to folks. It also provides for free tax preparation services to New Yorkers, and it's a wonderful resource. And so because of all the different things that we do, we're a small agency, but we have a large mission. We try to keep a lot of this information up to date on our website in multiple languages. And so I want to encourage you to visit our site because there are many resources on there. And if you find a resource or questions that you have that you wish we would put up there, feel free to reach out to us or reach out to Lisa and the chamber. We'll get that feedback and we'll work to incorporate that, because the more we can learn from you what you need, the more we can try to provide tools, because what we want is for businesses to be in compliance, of course. And so without further ado, I want to introduce first Tangela Rahman, who is our Director of Outreach. And so she'll be making sure that you all have the resources available to you that we have on our website, the different links, the FAQs that we create to make this accessible. And so that's Tangela, thank you for that. And we have Liz Wagoner, who is our Director of Investigations within our Office of Labor Policy and Standards. And she is the expert that will give you an overview of the changes that have happened to this law and what you need to know. So thank you, and I'll turn it over to Liz.
Thanks. Are we doing a Q&A, or are we doing it in that format, or should I just sort of go through the information about the new law? How do y'all want to proceed?
Yeah, can we just do, I have it down as like an overview to highlight some things. So since this is a roundtable discussion and the individuals on are mostly business owners, I love that this is the paid safe and sick, and we really need you to get us to understand in layman's term. But what keeps jumping out at me, and it's me being me, is the word enforcement, right? So I think for the purposes of this, it really is about what they can do to avoid any type of enforcement, right? Because the majority of our small businesses really are about taking care of their employees. What gets confusing sometimes is how they make sure to follow the regulations. So I think the overview is fantastic. The Deputy Commissioner did a great job in telling us your role, and I didn't know the name had changed for your agency. So it really does encompass now, because I know that we were a little not understanding why the Department of Consumer Affairs had gotten the title, but now it fits nicely. So I appreciate that. So this is a learning for all of us. I'll jump in. I really, like I said, want to make it engaging, and from the point of view of all of us, and for my businesses that can't be there, if I can throw in a question. But you're our experts, and in layman terms is always the best way, especially for those of us who really don't get some of this stuff. And that I'm talking for myself, of course.
Sure. So and yeah, on the agency name, we're all still getting used to it too. So we all get mixed up. So thank you for having me. I'll start off with just a brief overview of sort of what the law that's been in effect for several years provides, and then what's changing.
Perfect.
So the sick leave law in New York City was passed in 2014. And the basic framework was that employers who employ 5 or more employees are required to provide up to 40 hours of paid sick leave for their employees, and those with 4 or fewer employees were required to provide 40 hours of unpaid sick leave. In 2018, the law was amended to add safe leave, so it became the paid safe and sick leave law. And what safe leave is, the idea behind it was that when people are victims of certain crimes, in particular domestic violence, but also it protected our people who experience stalking, human trafficking, so often sort of thought of as gender-based crimes. They need to take certain actions in their lives to stay safe, which may require taking time off of work, court appearances, finding new housing, finding new childcare, right? Sort of a range of things when you're, experience something like that may require you to take some time off of work. And so the law said, okay, well, these are also additional protected reasons under the paid sick leave law. In addition to the original reasons, which were things like, to be able to go to the doctor if you were sick or if a family member is sick. Those are all covered reasons. And it is quite broad in terms of when an employee has a right to use sick leave. And so that's been the law for many years. What recently changed was the state, and that was just in New York City. The state of New York recently passed a sick leave law that went into effect in September, which actually—
September of this year?
That's
Okay.
right. And it actually contained more protections than our city law did in a number of respects. So for example, our law said that employees can't use sick leave until they hit 120 days of employment, so about 4 months into their employment. And the state law did not contain that 120-day cap. And so we amended our law to where, an employee can start using sick leave as they accrue it.
Oh, okay, interesting.
Yeah.
But so, and I'll jump in, we're having a conversation. So if most employers, from my history, is usually you go through the probation period, right? Where you don't get any type of benefits and then it starts. How does that impact the start of, for the new law?
Yeah, so as of September 30th of this year, a probation period would not be permissible under the law anymore.
Oh, interesting.
However, the way it works is, employers can choose whether they want to front load the sick leave at the beginning of the year, or if they want to use an accrual system.
That makes sense.
Where an employee accrues sick leave at a rate of 1 hour for every 30 hours worked.
Right.
So the employer has that option. It can't be less than 1 hour than 30 hours worked if they're using an accrual system.
Right.
So as a practical matter, an employee isn't going to have very much sick leave accrued at the beginning of their employment, but they are allowed to use it as they accrue it.
Perfect. Thank you.
So that was one of the changes. Another change, I don't know how much this will affect your membership, but domestic workers in private homes are now entitled to use 40 hours of paid safe and sick leave. Before, they had a lesser amount that was available to them, and so the amendments increase it to 40, so they're sort of in line with
what was it before? I'm sorry, Elizabeth. What was it? Because interestingly enough, we do have what we like to call entrepreneurs, right? Who tend to do this type of work. So what was it before?
So before it was,
and I don't mean to put you on the spot.
Yeah, no, it was actually pretty complicated, and that's one of the
Okay.
reasons the law was changed, just to sort of make it just sort of match what the requirements are for everyone else.
Okay.
But it was 2 days under our law, and then there is a state law that provides for 3 days off.
Okay.
And so combined, anyway, so now it's
Fine.
just, we're not looking at the state law on paid time off. We're just saying 40
Correct.
hours of sick time accruals, just like every other employee.
Fantastic.
So it simplifies it.
Okay.
And of course, it's the same accrual system, right? So if you have a part-time worker, right,
Right.
you would accrue kind of based on the amount that they're working. Other changes that went into effect on September 30th of this year. There's a new requirement that if an employer requires the employee to get documentation of the reason for using sick leave, then the employer has to pay any fees that the employee incurs to get the documentation, or any sort of fees for the documents themselves. Employers under the law now and under the law before are not allowed to ask for documentation of sick leave usage until the fourth consecutive day. So if an employee calls out sick, just one day, the employer cannot say, I'm only going to pay you if you submit documentation. It is only after on the fourth consecutive day, that the employer can say, okay, I'm going to need you to submit documentation to show why that it really was for a covered reason.
So the employer still has to pay even after the fourth day, or is it if they ask before?
They do. So if the employer has a documentation requirement like that, it needs to be in their written sick time policy that they're going to require it. So the employee kind of knows, and it isn't a surprise that they're going to be expected to get documentation. The employer, if they request the documentation, the employee has 7 days to provide the documentation.
Okay.
Yep. 7 days from return to work.
Got it.
Yep. And as long as we're talking about written policies, that is something we do often see in our work, that employers don't have written sick time policies. So it's just a sort of a common issue to kind of be aware of. The law does require employers to have a written sick time policy.
Elizabeth, I'm so sorry. So the written policy, especially as it covers this, does it matter the number of employees you have? Because most of the businesses in the Bronx have, under 10, 20. I have a handful that may hit 100. So when you're talking about the policy and the needs or requests through this policy, is there a number of employees that you need to have to make sure you meet the standards and all the regulations?
All employers need to have a written policy. But I want to emphasize, the point of it is really for the convenience of everyone. If you as an employer want your employees to call a particular person to say, I'm going to be out sick today, I can't come in, the policy should say how to do that, right? So it's really so that everyone on both sides are clear about how can I use this benefit, and what does my employer want me to do to access this benefit? And so it doesn't need to be very, very long, very detailed, right? It just needs to contain the basics so that the employee is using the benefit or knows how to use the benefit. And our website does contain information about kind of what those basics are that a sick leave policy needs to hit in order to be compliant. And then it's also in the rules, the sick leave rules. Take a look at those resources.
Thank you. I'm sorry. I keep interrupting you. Go
ahead.
It's
great.
Because I know I have some people saying that they want a Q&A just for those present. I'm jumping in, having a conversation.
Yeah.
Hopefully on behalf of what they're thinking, but I figure a conversation as things pop up, it's always good to have. But those on this site now, if you do have questions as we're having these conversations and Elizabeth and her team are walking through, feel free to put them in there, because we'll make sure that the questions, as I rudely interrupt, I will add your questions to it. But Anna will also be doing a moderated Q&A.
Yeah, and as we get those questions, we can add them to our FAQ and make sure that that's in the site. Because like I said, we really want to learn from your questions what employers need to know. And we have, as Liz mentioned on our website, also a sample of the Notice of Employee Rights. And that's in English and Spanish. You can download that off of our site. And again, what other resources you need, let us know.
Thank you, Commissioner.
Should we continue talking about some of the changes to the law?
Absolutely.
Okay.
I'm going to mute myself.
No, please don't. Jumping in is good. You know, and because I was more prepared to talk about the changes rather than the sort of the basics of the law. And I'm realizing that, you know, there are many basics that are useful for people to also hear. So I'm glad you're jumping in. Another new requirement is that employers need to let employees know how much sick leave they have available. The most straightforward way to do that, although not necessarily the only way, is on the pay stub to just say, you know, here's the sick leave you have available, and how much has been used, so that employees know that. And so previously that was not required to inform employees of that information. What we've sort of seen, what we've seen though is there's often confusion about the issue. Employees don't know how much they have available, and then maybe file a complaint, you know, because they, you know, think they have more sick leave available than they really do. And so, you know, sort of facilitating that communication between the employee and the employer.
Now, does it have to be an official way to do it? For instance, if I keep an Excel sheet and I don't put it on because I handwrite my paychecks, does that mean, am I doing the right thing to, you know, so if an employee asks, I can show them my Excel sheet?
It needs to be provided to the employee each pay period. It does not have to be on the pay stub, you know, like an email to the employee every pay period saying, here, you know, that would be fine, right? But it does need to be provided to the employee proactively, and not just sort of, yeah, let me know if you want to know. It needs to be provided in writing to the employee.
Okay, and I'll let you know tomorrow.
Yeah, yeah, right. But, you know, I think our hope is that this will also just sort of facilitate, simplify the interaction, and make sure that everyone's sort of clear on what the benefits are that are available.
Yeah, and if I could add, Liz, you know, it also, in addition to providing clarity for the employee, it also protects the employer, right? Because even though you might have a small business with kind of informal interactions, if you have these things in an email and it's in writing, then if an issue does arise, then that helps protect the employer. So it's good for both sides.
Yep. Yep. And just a note on sort of written documents. So we've talked about having a written sick leave policy. We've talked about now provide the requirement to tell employees how much sick leave they have accrued on a pay stub or in some other way. And then the third sort of big ticket item there is providing employees the written notice of safe and sick leave. And that's a document that y'all had mentioned that's published on our website. I want to emphasize that the notice of employee rights that we publish and which is required to be given to employees is not the same thing as a written sick time policy. The idea is, you know, the employees receive a document from the agency that explains their rights. The written sick leave policy is just the employer saying, here's how you use this benefit at my company. And so there are sort of two distinct requirements there for two different purposes. So just to make that clear. Okay, so a couple more requirements in the new law that are going into effect on January 1st. One relates to employers with 100 or more employees. The state law provides, and so now our law will provide, that employers with 100 or more employees must provide 56 hours of paid safe and sick leave. And so that doesn't change anything for small businesses. If you have 99 or fewer employees, it's the same requirement as before. It's the 40 hours. But employers with 100 or more employees must provide 56 hours of paid safe and sick leave. And then the other thing the state law did, which our law now will also do, is it includes some small businesses with 4 or fewer employees, if they have a net income of $1 million or more. So net income of $1 million or more, if you have 4 or fewer employees, you are now treated as a larger employer that is subject to the 40-hour requirement. And so those are sort of changes in terms of how much you're paying for sick leave, essentially, those 2 changes.
Okay, that's huge.
Yeah. I mean, I think, I think that what I've heard is there are not so many businesses with that small number of employees that will meet that $1 million
Right.
because it's not revenues, it's your profits.
Right.
So it's that would be a nice problem to have, I'm sure, for many of your members.
I would have to agree with you.
Yeah. But it is, I'm sure, we'll add coverage for some people. So
Okay.
important to be aware. And then, yeah, and so that's it for the changes in the law. We have resources on our website that, we've got the page up here, I see, that lays out, what those new requirements are. So folks can take a look at that. And then, just tons of great information on our website. A very long FAQ that kind of goes through all kinds of scenarios that you can imagine about, how, like sick leave, what the sick leave requirements are. It has a lot of examples,
Right.
sort of common issues that come up. So if folks haven't read that, it's a great resource to answer your questions, and we all refer to it all the time. Yeah.
So I have a quick question. This is probably me more than we try to, as an organization, keep the businesses up to date. The notification of these amendments and changes at the state and at the city level, how do the employers know that this is happening? And this is, I'm not an employer, so technically, but how do employers know, especially the small businesses, know that these things are coming into effect and that these changes are happening, and they have to make sure to make their necessary changes?
Angela or Sandra, do you want to hop in on that one?
Yeah, sure. And then also, Liz, there's a question in the chat about what if employers provide more than the 40 or 56 hours, and of course, like, we want to make sure, more generous employers feel like they can provide more generous benefits, of course, to their employees. But in terms of the awareness, I mean, I think this is why we try to have events like this and try to go out and be proactive. And like I said, our commissioner personally goes and visits our businesses. We created a program within our agency to go business to business to make sure that they have our updated information. We translate as many materials as we can into as many languages as we can,
right,
so that it's accessible to people. But we realize it's a challenge. It's a challenge. Small businesses have so much going on, and there's so many changes happening now with reopening.
right.
The laundry list of requirements, it can be overwhelming. But I think that our hope is to get the message across that this is about communication with your staff and making sure that they feel like they understand what their rights are, they understand what their responsibilities are, and that it's a two-way street. And I think that when we go into workplaces, we're going in to ensure that businesses are trying to comply with the law, and we'll work with them to figure out, okay, what are you missing? What needs to happen? What do your employees need to know? Because we know most of the businesses are really trying to do their best by their employees and really trying to protect them,
Yep.
And make sure that they have the benefits that they deserve. And so, we're trying to do our best to make sure that businesses are equipped with the tools that they need to do that.
And I appreciate that. And this is really what these conversations, you're exactly right. In a non-threatening, just ask the questions, and which is what we encourage our businesses to actually do. And at the same time, we educate ourselves on it. just to make sure. I think the one thing had always been, you get these small businesses that say, well, I didn't know, right? So if you get the I didn't know, is there a cure period? Meaning, for those who may not understand what I mean by cure, is there a time frame in which you allow the employers to fix it before they get a violation? Or, the unfortunate truth to some degree sometimes is employees react to employers with, with not so pure intent. And so, and to your point, employers are most of the time doing right by their employees. So is there a time frame from the point of an inspector coming in to asking for documentation to a point of an employer being able to fix if there's an issue and they don't see a violation? Does that even exist? I'm new to all this, so forgive me if the question is like out there.
Yeah, no, it's a good question, because I think it goes to our enforcement process. In terms of enforcement, when it comes to small businesses, it is effectively exclusively complaint driven right now.
Yeah.
We do directed investigations, which are sort of proactive investigations of very, very large companies, and in particular sort of initiatives in sort of particular industries.
Right.
But most of our cases are complaint driven, which means that a worker contacts us saying, I used sick leave and I was fired. My kid was sick and they said, well, if you can't come in today, never come in again. Or, I used sick leave and I wasn't paid, right? Those are the kinds of complaints that we receive. And when we receive those complaints, what we typically do is assess, whether this seems likely to be an issue specific to that person or potentially indicative of a workplace-wide problem, and then we investigate accordingly. Employees, when they are not paid or not allowed to use sick leave or are not paid for sick leave, there are specific amounts in the law that they're required to be paid, which is between $250 and $500 per instance of not being allowed to use or not being paid. But then there's sort of, for some of the other requirements I described in terms of the document record keeping requirements, giving out the notice of employee rights, having a paid sick leave policy. There are civil penalties associated with those violations as well. And so, we particularly when it comes to small businesses, do often find ourselves waiving the civil penalties to a significant extent in exchange for a consent order where the company commits to come into compliance.
Okay.
It's obviously on a case-by-case basis, but we, certainly want to make sure our goal is future compliance, and our goal is to make sure that employees are fairly compensated. To be frank, we do not waive employee relief, because people have rights, and they need to be compensated when their rights aren't respected. But in terms of civil penalties, we are looking to make sure that we have compliance, particularly when it's a first-time violation.
Thank you.
Yeah.
Okay.
There's a question here. I'm sorry.
Yeah, I see a few questions.
Right.
Yeah, so I can go ahead and should I go ahead and address those?
Sure. Yeah.
Yeah. So I'm going to take them in order. So first is companies that provide more time than 40 or 56 hours as PTO, does this cover the requirement? The short answer is yes, it does. What employers need to do where they're offering, paid time off, where, there's not a restriction on what the reasons are for using the time, is they just need to say in their PTO policy where they're informing employees, this covers the New York City paid safe and sick leave law, and you can use this PTO for any of the protected reasons and without any other restrictions that are prohibited by that law, right? So the idea is if you're using, if you have a PTO policy, if somebody gets sick, you can't say, well, you didn't give us 2 weeks notice of your intention to use PTO, so we're not going to, pay you for this sick time, right? So you just need to, as long as you're letting people use the PTO when they get sick, there's no problem. And that absolutely is sufficient to comply with the sick time law. The next question here is, if you prepay sick leave and it's used, what happens when an employee gets sick later? So when the benefits are used up, that's it. And we do get cases like that, where maybe the employer provides PTO to satisfy their obligation to provide paid safe and sick leave. Maybe they front loaded in January. The employee took a vacation in February and used up their 5 days, and then they got sick in March. So in that situation, we would say, well, there's no coverage, because you already used up your benefit. And that does come up because employees maybe don't understand. But that is a situation where the employer would have fully provided the benefit in that example.
Okay.
Next, if an employee is out for 5 consecutive days and is asked for a note and they do not produce the note after 7 days, what happens? Can they be denied pay for the days out? So yeah, under that example, yes, they can be. And I'm only hesitating because, the answer is yes, but the employer cannot require the employee to provide details of the sort of confidential reasons that they were out sick. They can require verification from a medical provider, or if it's safe leave, that might be from the court or from their attorney, or sort of whoever is involved in the circumstances. Sort of affirming that yes, this person was out for a covered reason. I was involved and I know that. They can't sort of require them to say what specifically the medical condition was or the details of the domestic violence situation. And so that's my only hesitation is, once the documentation affirming it was for a covered reason is provided, an employer does need to accept that and pay for the leave. And there can't be sort of any further requirement that it more details be provided.
Interesting. Okay.
Mm-hmm.
So the follow-up, right, is what if they never produce the note?
Right.
You already paid them within the 7 days. Can you regularly take back wages? I've never come across that. I am not sure, honestly. It strikes me that there may be some. I'm not sure whether self-help like that is permissible. I would hesitate to give a thumbs up to that, and I would suggest consulting with your attorney. I'd probably be more free with it if we had encountered this issue before, but I personally would need to look into it before being able to answer that question.
Fair enough. But to the commissioner's point, I'm not sure if you entered in, I apologize. If the employee just never comes up with a note, what happens?
Then paid leave would not be required. And but again, here we're talking about a situation where the employee has taken more than 3 consecutive days of paid sick leave, because the note cannot be required if it's day 2 or day 3. It's only once we're into day 4 that the note can be required.
Perfect.
Mm-hmm.
So I know, see how we practice everything and nothing, we're following no rules here. I know that we had some moderated questions, and they're really important questions. So Anna, if you don't mind, we'll jump in and between the young ladies, they can fit in. And then of course, we're gonna throw in questions as we go along.
Okay. So the first question we have is, why was a paid safe and sick leave law amended?
Yeah, so that one, I think we actually did go through that because it was really to align it to New York state law, and then to add some clarifications in the law to kind of make it work better for everyone. What it was, I think, the short answer to that.
So I have a question in between that. So if the state decides to change it again, because I know there's all this talk when they go back up to Albany, will the city always try to keep up with the state, or?
There is a provision in the law that says that if the state changes their standards in a way that raises protections, then our law automatically incorporates that without a need to go and amend it. So we want them to match. and that's sort of the best way to just have a match. So if you have, some operations in Queens and some in Westchester, you're following the same requirements for all your employees.
That's a great, okay, I didn't know that. Okay, go ahead, Anna, sorry.
Okay, so for the second one is what are the new obligations for employers under the law?
We went through that one.
I think we went through that.
Yeah.
Okay. So what other resources are available to employers to comply with paid safe and sick leave law?
And so there, I think our website has a lot of great information. So we've got, the notice of employee rights, which is that document that employers are required to give out to employees. That's on our website in 26 languages. Employers should give that notice out in English. And then if you have 5% or more of the employees in your workforce that speak another language other than English, find and print out the language that they speak on our website and give that one out as well.
Anna, can you just show the document she's talking about so our guests can see what?
So here, this is the notice of employee rights. This is a new one that incorporates the new requirements. So I guess we had like 26 languages of the old one. This new one is much simpler and easier to understand. And I think folks are sort of quickly trying to turn around the new version. So for now, we just have English and Spanish, and we will very soon have all of those translations of the new one here.
Yeah, and we could share those additional translations once it's available. And so we will translate them in the top 26 languages.
So that's one. Do you want to open it? You want to click the notice of employee rights to show folks what it is? Just it's down a little bit with your
notice
mouse.
a little quick right here.
There you go. Yeah. Oh, where is it? Oh God. Go down a little bit.
Oh, notice right there.
English, and click on English there. So this is the document that employers. That's what it looks like. So it's just sort of a very simple statement of the sort of basics of the law's requirements.
And so every company should have that, no matter how big and how small.
They should give that out to their workers.
Okay.
Yep. So then we also have a bunch of tools around sort of timekeeping for safe and sick leave. So I think a way to sort of easily calculate the 1 hour for every 30 hours worked accruals. I think many people just use their payroll company to do that, but if that's not something that folks use, this is a tool to sort of do it in-house. We have a bunch of forms that employers can use for the sort of, for example, if you want the employee, so employers are allowed to ask employees to verify that they went out for a covered reason. It's different from a doctor's note. So, say an employee's out for 1 day, and, the employer's not allowed to ask like, oh, well, what was wrong with you? They can't do that, but they can sort of require the employee to affirm in writing, like, yes, I used sick leave for a covered reason. We have a form on our website that employers can use if they want. It's voluntary. Employers don't need to collect this, but if you want a process for making employees affirm, like, yes, I use sick leave for a covered reason, we have a form that you can use for that purpose. We have a model form that employers can use if they want to ask employees to provide notice that they intend to use sick leave. So again, that's not required, but some employers want employees to give advance notice. And they
Right.
can, if you're going to go out and get surgery, like, let me know in advance. And they are required to request advance notice of an intention to use sick leave. And so that's
amazing. You can basically do a whole booklet with what you have available to you.
Yeah, there's a lot.
Print all that stuff.
There's a lot.
So that's more work for the chamber. So our members can literally call us and we can try to put a little packet together and give it to you to make it easier. There's a question here that says our company works on a fiscal year. Should we use those dates instead of a calendar year?
Yeah, so employers can pick their own calendar year. So you'll see in the notice of employee rights, there's a space for the employer to fill in what their year is. And the reason the year matters is because employees can carry over unused paid safe and sick leave. If they don't, they only use 2 days 1 year, they carry over 3. And so, but what's the carryover date, right? It depends on what the employer's year is. And so there's no requirement to use the calendar year. The employer can use whatever year they want. They just need to write it into the notice of employee rights so that employees are aware of that information.
You can cap the amount of time you carry over.
Yeah, you can. Yeah, because employees are only going to be the way it works is employees can only use 40 hours in any given year. And so the law doesn't contain a cap on carryovers, but as a practical matter, you're not going to be able to use more. 40 now, starting in 2021, it'll be 56 for employers with 100 or more employees. But you're not allowed to use any more than that max that's in the law unless the employer provides a more generous policy. Employers, of course, are welcome and encouraged to offer much more sick leave than what the law requires. And so they may allow for carryovers of great and use of greater than 40 or 56 hours, but they are not required to. Yeah.
Okay, perfect. I'm sorry, Anna, go ahead.
Okay. Are enforcement considerations being made to ensure businesses aren't overly burdened during these difficult economic times?
Right.
Yeah, I mean, so I think we talked about some of those, and just in terms of how we do enforcement with small businesses. In terms of the sort of specifically geared towards the new requirements for the pay stub requirement, employers that are not able to operationalize that requirement have until November 30th. And we heard from some employers like, oh, my payroll company isn't set up to, write the accruals on the pay stub. So I need a little time to work with them to figure that out. And of course, that's perfectly reasonable. And so, we are not, if we see, the employer saying like, I tried and I'm having these difficulties, getting that information out to my workforce, we're not going to charge civil penalties for that. But obviously, at the same time, we do want to see employers start, making good faith efforts to implement that requirement. And we are also, working on additional rulemaking, to sort of align our rules and just sort of, I think, welcome feedback from employers on, any area of our law that, or of the new requirements that they'd like additional guidance on. So.
We have another question. It says we have over 100 employees. Will the part-time employees still earn 1 hour for every 30 worked?
Yes. So the 1 hour for every 30 hours worked requirement is the same. The new amendments don't change that at all. So now, as with before, employers can choose to either do accruals at 1 hour for every 30 hours worked, or front load if they prefer. And that requirement applies, or has always applied, to part-time and full-time workers. Obviously, part-time workers are accruing less, because they're part-time, but that it's the same setup.
So they're entitled to, so I'm going to jump in on that one. They're entitled to the 40 hours of paid safe and sick, even though they're part-timers.
Once they accrue it. And so, if you're a part-timer working, 15 hours a week, I do a little math to figure it out, but I'm not sure you would ever get to 40 hours.
So they can't just come and complain, let's say, call you and say, I took a week off, I'm entitled to a week, and I'm not being given that time.
Right.
And this one also is interesting because it's over 100 employees, which means this company then would have to do the 56 hours.
They would, starting January 1, they would have to do the 56 or allow up to 56 hours of use. But right. So I think for a part-time employee in that situation, we're going to be looking at, how many hours were they working, right? If somebody were to file a complaint with us, that's what we would look at. and would ask the employee about, I think, before opening an investigation, to be sure that, you know, there's even a possibility that they would have had that amount of time available.
Fair enough. Okay. And I'm sorry, for another question?
The last one. What suggestions do you have for employers to ensure they're in compliance?
Yeah, so I think I strongly recommend reading the FAQs as a place to start. You know, that really is going to tell you everything you need to have in mind to be sure that you're in compliance. And those have been updated to reflect the new requirements of the law. So that's really the best resource. You are also welcome to reach out to us with specific questions. People often do. The person who mans our intake line, Ingrid, often gets questions from employers. You know, and often, you know, we'll sort of point them to the right place in the FAQ, so answer those questions. We recommend that you take a look at your written sick leave policy. Make sure, you know, it matches what the law requires and sort of what you see in the FAQs, and give out the notice of employee rights if you have not before done that. It's a very it's required, and it's a very simple way to sort of make sure employees know that they're entitled to use sick leave.
Okay, I have a participant who raised their hand. I'm going to ask that since we can't hear you, if you can put your question in the chat before we wrap up. Jessica, I believe that was you, if I saw the name correctly. Okay, sorry. And here I thought we were just going to chit chat for a few minutes. So if I were to simplify everything that you just said, which is easier said than done, and I were to say 3 steps. Step 1 for the employer should be know how much sick time you're giving your employees by providing them a written policy.
I think that's great advice.
Right?
Yeah.
Make sure that they are notified of what they have on every payroll, whether it be monthly, bi-weekly, or weekly.
Yep.
And then there's the document of, so the question is, you have all these great documents, which we're going to be printing up. Should those documents be given to the employees as an example of things that they should be aware of as part of the policy, or as it goes? For instance, you'll tell them they need a note after 3 days, but there's a form there that says, you know, fill this in with the request, or I've used this time. All those forms that you're saying, should the employee have those forms ahead of time, just as a what if?
I wouldn't recommend it unless the employer has decided this is the document I want to use. You know, it may be that, you know, you're a small company, you don't deal with a lot of paper. Really what you want is for employees to, you know, call you as soon as they know and tell you when they're going to use sick leave, and you don't want to sort of deal with all this paperwork, right? So that's an individual company decision. You know, there's no requirement that you have something in writing stating this is the date that the employee told me they wanted to use sick leave, right? None of that's required. So it really is just going to be a company by company decision. The ones I would absolutely recommend giving out to employees, and which, because the law requires it, are the notice of employee rights and your company's written sick time policy.
Is there a template for people who don't have a company policy because there's like 3 employees or something, just to protect themselves?
Yeah, there's not and so instead we have kind of bullet points, and the reason we don't is because a lot of what has to go in the policy depends on whether the company is choosing particular options to include in their policy. So, you know, we don't require you to require your employees to give you advance notice of using sick leave, right? But if you want to require employees to give advance notice of using sick leave, you've got to say in your policy, here's how much you have to give us advance notice, here's how much advance notice you want. So there's a lot of like options like that, where it's like, you know, if the company wants to have sort of a stricter requirement that the law allows them to have, then they've got to just put it in their policy that that's what they're requiring.
Okay.
Yeah.
Perfect. Well, believe it or not, it is 7:30. Time flies when you're having fun. So I can't tell you how appreciative we are that you had this conversation with us. We're walking away with tons of great information. And, because although you have the website and all this information, most people, including myself, will probably not read through it, right? So the highlights and things like that are great, but actually understanding it from the agency that oversees it makes it so much more helpful. My hope is that everyone who is on and will be listening to this through YouTube or otherwise understands that we're all working together to make sure that we get over this horrible hump that we call this pandemic, and that our businesses eventually will get to some sort of normal, whatever that may be. I know that our hope is that we move as quickly as possible to reopening. So before I close it out all completely, is there something the businesses should know as we move our way into reopening? And it's odd for me to ask that because the governor's looking to shut us down to some degree, right? So we're in this push-pull right now. We like to stay on the optimistic side and say, we're going into the holidays, the new year will bring new things. Is there anything specific an employer should know from your department, from your expertise, of something to think about before they open those doors again?
I would say you've got to monitor the state guidelines because the businesses were in different categories of reopening. And so they tried to group them together by industries, given the risks that certain industries have more. Like we know that indoor dining, of course, was one of those areas that we knew was going to tend more towards rates of infection. And so the other thing is just to remember the core principles that the Department of Health and Mental Hygiene has been reinforcing. And they've put out a lot of great material on their website. So I would definitely recommend that site. They've got sample posters, sample signage, all the requirements that you need to have. And remember, to provide your employees with personal protective equipment, maintain social distancing wherever possible, having your face mask requirements, which they also have signage about. So, I think the New York City Department of Health site, which Tangela just put in the chat, is a great resource. And they've updated and translated many of these documents so that, like our site, we try to create these tools that employers can use if they want, so they don't have to reinvent the wheel. So we hope you find those resources helpful.
Absolutely. So somebody jumped in with one last question. Is the part-time employees max 40 or 56 as of 1/1/21? I'm going to say 56, correct? If it's over 100 employees?
That's right. That's right. And again, my question would just be, will the part-time employee work enough hours to ever get to 56?
Right. And that's the part that's scary, right? Because you think part-time employees are like, wait a minute, I'm giving them 7 days out? But in reality, they have to earn those hours.
They've got to earn it.
Right.
And so, what's part-time, right? If you're talking somebody working 35 hours a week, I might earn it, right? But somebody working 20 hours a week, I'm not sure that they would. Yeah.
Earn the time. Okay.
Yeah.
So anybody else who has any further questions, we're going to ask you to follow up with helpdesk@bronxchamber.org. You can always call our office. Elizabeth, Commissioner Tangela, right? Oh my God, I told you I have to kill at least one name in my presentation. I cannot begin to thank you. We really look forward to working with you to make sure that our businesses stay on point where they're supposed to. And we appreciate you taking an evening to share with us all this information and truly appreciate your partnership. So thank you.
Thank you so much for having us.
Thank you so much.
Of course. Have a great night, everyone. And for everyone on board, you can always have other partners and businesses check our YouTube or social media platforms. This will be available as of tomorrow. Have a good one.
Thank you.
Good night,
Thank you so
everyone.
much.
Thank you.